Hello guys, this is Professor Kachalia and today we are going to discuss the CA Inter amendments for November 2022 exams. Okay, pay attention, law paper, very few amendments are there but interesting amendments are there. Okay, let's solve them together. First one, the first one is with respect to the rectification of the name of the company. As per section 16, you should be aware, I am hoping you are aware that whatever name of the company you select, it should not be phonically or you can say with respect to the spelling or the name or particular name which is already registered, you should not copy them, right? So here what the provision says, if the name which you have taken is very identical or very resembling with any particular name of the company which is already existing, in that case, CG will have the power. CG has all the powers anyways, but CG will have the power to order you to rectify your name, change your name. Now, what is the change? What is the amendment over here? Okay, so provision says that CG may direct the company to rectify the name. That was old provision. New provision is given in green color. They are saying when such a direction is issued, yes, the company shall within 6 months rectify the name. This 6 months is the old provision. Now, new provision says within 3 months, the company should rectify its name by passing an ordinary resolution. Is that clear? Simple provision, yes. You have to rectify within 3 months. Old provision, 6 months. Update in your notes. Going further, sir, what is all this? This is the same entire section 16. I just brought it over here so that all those students whose notes are not updated, or if you do not know what is section 16, you can refer through the notes from here. Yes, all these are there in my book also. If you are having my book, you did not go through the entire thing. This is for those students who are not having my CA Inter Law book. Okay, they can refer section 16 from here. Other students have taken the latest book. 3 months is updated over there. If you have purchased the book 1 month back or so, in that case, it will be 6 months. You must rectify and make it 3 months. Okay. One more amendment, one more amendment, one more amendment in the same section coming by the end of the section. It says, if the company makes any default, told you know, rectify within 3 months if CG orders. If the company makes any default, yes, in that case, CG shall allot a new name to you. You don't listen to CG. CG says, I don't care. I will allot a new name to your company, and whatever name I will allot to your company, you have to accept, accept that name as a name of your company. Yes, CG will inform the ROC. ROC, register the name of the company with the name that I am giving you and issue a fresh certificate of incorporation for the company with the new name, because the company did not rectify the name even after me telling the company to do so. But my dear friends, of course, you still have the option given under section 13 to change your name to something new, something different, whenever, however you want, by complying to the provisions of section 13. CG gave you a new name because you did not rectify the name as CG ordered you. Understood? If you don't like that name given by CG, well, you have a chance. You always have a chance. What? Change the name and select a new one as per section 13. So that again in green color is your amendment point. Clear? Going further. Next amendment comes in the chapter of charges. In the chapter of charges, what is the amendment? First of all, there is a small provision with respect to the registration of charge which starts from section 77. This registration of charge, I have given you as per before the ordinance or after the ordinance, whether your charge is created depends on that. Theoretically, it is there in your book. Diagrammatically, I have shown it to you over here. Okay. Again, if you have my notes with you, then all these things are there in your notes. What is new over here? New is this amendment which has come in the rules of the charges chapter. Okay. What is that? It says nothing contained in this rule shall apply to any charge required to be created or modified by a banking company under section 77. Are you a banking company? Yes, sir. Okay. Then you wait. If you are a banking company, then none of the provisions with respect to registration of charge, which are given in section 77. 77 is all about registration of charge. None of the provisions with respect to registration of charge will apply to you. Yes. In favor of Reserve Bank of India when any loan or advance has been made under the subsection 17 of 4D of the RBI Act 1934. So what they are saying, if at all you are a banking company and you have created a charge, and that charge which you have created, you have already created and done the registration of that charge or modification of that charge as per the RBI Act. Well, we have been saying this since day one, since my basic class, the first class of law that I told. In the first class itself, I have made this point very clear. The law, company law, is made in general for all the companies. But if any specific law is applicable to you as a particular type of a company, you should follow your law only, right? So if you're a normal company, you follow the Companies Act. If you're a banking company, well, and the provisions with respect to this charge or anything is given in your banking company related law, applicable law, that is the Banking Regulations Act or the RBI Act. First priority to your specialized law. Second priority to this general law. So same provision says, if you are already registered under the RBI Act, then no need to comply with the provisions of the Companies Act if you are a banking company. Okay. Then management and administration chapter, what we call as general meetings, right? This chapter is mostly asked from and applicable from section 96 to 122. But in 94, there is a small piece of amendment. Let's quickly have a look at the amendment. It is about the place of keeping the books, yeah, inspection of registers, returns, etc. This blue color, whatever you can see, is same from my textbook. Same provision has been copy pasted. Nothing new is there. Okay. With respect to the place of keeping the books, registers, where you should you keep at the registered office of the company? Can you keep it at any other place? If you want to keep, special resolution required to be passed, not to be passed, same provisions are there. You can read them. I will jump on to the amendment. Amendment is what? Books of accounts, records, vouchers. Sir, those days are gone, sir, when we used to keep physical books. Now everything is in electronic form. Well, then the provision says, provided that the particulars of the register or the index or the returns as may be prescribed means all these other things shall not be available for inspection under subsection 2 or for taking extracts or copies under the subsection. Meaning, here they are saying, what is the meaning of the words as may be prescribed? Sir, can we just elaborate it? Of course. Let's read this whole point. Any such member, debenture holder, security holder, beneficial owner, any person may take extracts from the register or the return or index without payment of any fees. Of course, you are a stakeholder of the company. You can require a copy of such register or the entries of returns paid, payments made, whatever required on payment of such fees. If you require a copy, payment of such fees, you want to just take extracts from that, no fees required. Now, exception over here. Exception. What does it say? Provided that such particulars of the register, whatever as may be prescribed, shall not be available for inspection, or for taking extracts under this subsection, under the subsection 2. That is over here. Okay. Now the question is, sir, what is the meaning of this as may be prescribed? And that is the amendment exactly. The meaning of the word as may be prescribed. You want to know the registered address or address in case of body corporate or email ID, unique identification number, their PAN card number. It cannot be written. It should not be written as PAN number, because PAN itself includes PAN, N for number. But anyways, I have just taken the notes from the institute's material as they have written. Okay. So your PAN card number, basically, all these things, they are saying if you are falling under subsection 2, in that case, you shall not be allowed, or it shall not be available for you. So what is subsection 2? Oh, well, that you should read on your own. I have already given it to you. Not extending the lecture unnecessarily, right? Declaration of dividend. Very simple provision. You know, in dividend chapter, we have an answer known as sources of funds to IEPF account. Yes, if you're my student, you can also answer in the chat box if you want. Sources of funds in IEPF account. Do you remember this? Yes. If yes, we have made a long list of what are the different sources from where money can flow into the IEPF account, right? Okay. Here there is an addition. They are saying all the shares which are held by the authority in accordance with the proviso of section 90 subsection 9. Sir, what is section 90? I have given the name over here for your reference. Investigation of the beneficial ownership of the shares in certain cases. And all the resultant benefits which are arising from section 90 without any restrictions, all that money, all the benefits, all the funds which you are receiving should be transferred to IPF account. So one more addition in the sources of the funds to the IPF. Is that clear, everyone? Okay, simple one. Section 135 about CSR. What is the big amendment in CSR? Again, sir, in the last attempt, already there were so many amendments in CSR. Let me tell you. Last attempt, we told you that CSR related activities, if you are doing anything with respect to COVID-19, COVID vaccination, or COVID healthcare facilities, or COVID medicines, or any COVID related infrastructure, COVID vaccination to other than employees, all these things which you are providing will be included as a part of your CSR, and we had included it as a separate point, right? Now they have said that these COVID related activities, which were all already given separately, it will all form an integral part of Schedule 7 activities. So basically what they are trying to say is COVID related expenses, research and development expense, vaccination expense, whatever, as a company, if you are incurring, it's all treated as a part of your CSR. Okay, that is how I have summarized this point. Wait, game is not over. Something more with respect to CSR. They are saying every company to whom CSR is applicable, you must furnish a report, right? We know that. This report should come in CSR2, form number CSR2. You have to furnish it to the ROC for the preceding year 2021 in CSR2 and onwards, meaning after 2021, every year it will come in CSR2 as an addendum. Addendum means attachment. The CSR2 form will be an attachment to your account of company AOC. AOC form AOC 4, AOC 4 XBRL, and AOC 4 NBFC. NBFC, non-banking financial corporations, IND AS form requirement. That is whether you have complied with the IND AS requirements or no, you have to file this form. So just few names of extra forms. I won't say this is compulsory or important for you to remember these form numbers. No, normally in CA courses, these form numbers are not very important, but yes, if you are lucky, they have the liberty to ask. Okay, provided that for the preceding financial year, that is 2021, form CSR2 shall be filed separately on or before 31st March 2022. So for us, the date is already gone. After filing from AOC4, as the case may be. This won't make much sense for us because we are right now in the month of July, August over here, and this date, 31st March 22, is long gone. Small change again. Books of accounts, section 128, to be kept by the company. Everybody knows, right? From the financial year commencing 1/4/22, there was this provision. Onwards, every company maintains software, electronic form, books of accounts allowed, and all that things. New provision says instead of 22, we are making it 23. Just a change of date from 22 to 23. Small change. And this is a very interesting change. Very interesting change. Guys, this is very interesting and very important also. This is important sign. Important. If you see the amendment sheet of the institute, you will find that provided that for the preceding year 2021 from CSR2 has been filed separately on or before 31st May is the date given over there. What date did you see over here? 31st March. I have brought it intentionally. Pay attention. This date, 31st March, then they amended 31st March and they brought a new date, 31st May. This date of 31st May is there in the amendment part, but that is because amendments till 30th April 2022 are only applicable for your November 22 exams. Okay. After that date, there was yet another amendment where this date also is now scrapped and a new last date has been given, that is 30th of June 2022. Of course, practically speaking, 30th June is also gone, 31st May is also gone, and your 31st March is also. All these dates are gone. Okay. But why am I specifying this over here? Because in the institute's material, if you see 31st May is specified. And if you read the Bare Act with where amendments are there, the date has been updated to 30th June 22. This type where difference in opinion can be there, arguments can happen, debates can happen. Such type of questions will not come in exam. But if it comes, you are expected to write what? I will tell you, you are expected to write both these dates from my side. Specify these date as per institute material and specify as further amended, the date has been updated to 30th June. Understood? The 30th June date is not updated in our institute's amendment sheet, which has been released very latest. Okay. So this is one interesting and latest amendment that I wanted to bring to your notice. That is why I kept it separately and I did not include anything over here. Understood? That was the main purpose. Otherwise, this is my final message to all of you. Yes, notes, books, any suggestions, any advice, any help, anything you want, videos, anything you want, batches, live you want to attend, online you want to attend, anything you want, guys, feel free to get in touch with me. I will honestly be very, very happy to help you out. November 22, May 23, whenever is your attempt due, that is the target. We must clear these exams and then step into the new world of CA final with a feather of CA inter cleared and articleship already undergoing. Understood? Long way to go, but the journey will be amazing ahead. Right? I will see you around with many more such videos. Just one request, guys. If you want to all these videos with respect to amendments, revisions, updations, RTPs, anything, all these things, whatever you want, write it in the chat box from where I can read them. I can know what my students wish, what my students need, and thereafter, do not forget to like and share and subscribe to this channel. Reason I will tell you, only if you like and subscribe and share will this video spread to other people. When it spreads to other people, everyone will give in their requirements. Understood? That way, I will come to know what lot of students need and I will make my videos accordingly. Understood? This like, this share is nothing but a motivation for me to do something different, something new every time. And that is why don't forget to like and share the video. And I will come up with something new in my next video, always with some small revision clips on Instagram as well. So follow me over there as well and let me know if I can help you in any other way. Until then, Harsh Kachalia signing off. God bless you all. Thank you.